Shalom, shalom, shalom. This is Yah is Magnified, and I'm back with another informative video. Today's video is titled Court Counsel Response to Affidavit. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, I need you all to hit that like button. And if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. And also, guys, when you all see something that you like, feel free to share my videos to whoever you want to share them to. Let's continue to apply this pressure. And let's continue to move forward. So without further ado, guys, let's get to the subject matter at hand. Okay, guys, so now as you all can see on the screen is in fact the letter that my aunt received from the court counsel. We're going to go over this letter in its entirety, guys. But, I will give you all a heads up that she was kind of disrespectful in this letter, guys. You know what I mean? She was disrespectful to my aunt in this letter. But don't worry, we drafted our response already. I didn't send it to him yet. I'm just waiting for him to reach back out to me. And I want to do this video real quick. So, now as you all can see, the document is from where? The Superior Court of California. So shout out to the brothers over in California fighting that good fight, applying that pressure. Y'all keep doing what y'all doing, man. Keep y'all heads up and continue to fight that good fight, guys. Don't stop, don't quit. All right? We're coming from the County of Los Angeles. Then it states what, guys? March 2nd, 2023 is when the letter was written. Okay? Which was what? This month, this year. My ARC name and address are crossed out. And the reason for the letter is what? Correspondence received at the Stanley Moss Courthouse. Then it states, Dear Mr. Blank, who is my aunt, right? I cross his name out. And it states, a document entitled Affidavit of Blank was received at the Stanley Moss Courthouse on February the 22nd, 2023, and was forwarded to me for a response. So again, the document was received at the courthouse. They forwarded to her for a response, right? So this is her response, right? Her response is what? The document is an incomprehensible legal nullity with no lawful purpose or effect. Guys, she said that about what? About the affidavit. So she's saying that the affidavit is a document, right, that is incomprehensible legal nullity with no lawful purpose or effect, right? But not only did she say that, she said that in her response, right? But her response was in what? Letter form. Red flag number 1, guys. But let's continue. Then it states, the document, I already read that. Let's read the next sentence, guys. Then it states, consequently, right, the correspondence will be discarded and no action will be taken in response to it, which should be, will be taken in response to it. But I guess she was so upset about what was written in the affidavit that she was probably rushing and upset. And you know what I mean? You know how these fake people are, man. You know what I mean? These evildoers, you guys know how they are. But let's continue. Then it states, for further guidance, you may want to seek counsel from a competent legal source. So now, she responded to an affidavit by a letter, but telling my aunt to seek counsel from a competent legal source. She can't be serious. And she's supposed to be court counsel, right? She can't be serious. So, since we're talking about an affidavit, let's go to the definition of affidavit and see the purpose of an affidavit. Let's go there real quick, guys. Let's break this letter down to a T to make her look even more stupid. But now let's go again to the Black Law Dictionary and read the term affidavit. Let's go there. Hey, guys, let's pick this up at the very top where it states affidavit. And it reads, a written or printed declaration or statement of facts made voluntarily or confirmed by the oath or affirmation of the party making it, taken before an officer having authority to administer such oath. Case law to support that, guys. Let's pick this up at the very top. Then it states, right here, let me highlight that. See if I can highlight that. Right below that. Right below that, it states a statement or declaration reduced to writing, a sworn to or affirmed before some officer who has authority to administer an oath or affirmation. Case law to support that. Now let's go down to the second highlighted area, guys. And it reads, affidavits are of 2 kinds. Those which serve as evidence to advance the court in the decision of some preliminary issue or determination of some substantial right, and those which merely serve to invoke the judicial powers. So again, guys, by her trying to call an affidavit loyalty and unlawful. No, bruh, she don't have a clue what she's talking about, okay? Because we know that an affidavit serves as what, guys? Evidence. Shh, don't tell nobody, guys. But an affidavit is evidence, okay? Evidence, guys. So now, let's go to California, since we're done with California, and read California evidence code to further prove that. Let's go there. Okay, guys, as you all can see, we're coming from the California legislative. Now, let's pick this up at section 215.5, right? Coming out of Article 2 right here, guys. Article 2 affidavits, 2009 to 2015.6. So now, let's read it. 2015.5 clearly states, guys, whenever, under any law of this state, or under any rule, regulation, order, or requirement made pursuant to the law of this state, any matter is required or permitted to be supported, evidence, established, or proved by the sworn statement, declaration, verification, certificate, oath, or affidavit in writing of the person making the same, right? Let's read the parentheses, other than a disposition or an oath of office or an oath required to be taken before a specified official other than a notary public. Such matters may, with like force and effect, be supported, evidence, established, or proved by the unsworn statement, declaration, verification, or certificate in writing of such persons which recites that it is certified or declared by, right here guys, declared by him or her to be true under penalty of perjury. You see? So, once you file an affidavit and you declare to be true under penalty of perjury, that affidavit is now submitted into the court as what, guys? Evidence. Don't tell nobody else, though, all right? But let's continue. And 1, if executed within this state, states the date and place of execution, or 2, if executed in any place within or without this state, states the date of execution and that is so, and that it is so certified or declared under the laws of the state of California, the certification or declaration may be substantial to the following forms. And it just tells you again, if executed within this state, I certify or declare under penalty of perjury that the foregoing is true and correct. You date and sign your signature, guys. After you do that to a sworn statement, that sworn statement now becomes evidence into the court, guys. So for the lady to go back, let's go back to her letter real quick. Let's go back to her letter, knowing what we know. Let's go back to her letter. Now let's pick it back up at the second paragraph. Again, this is her response, guys. It states, the document is an incomprehensible legal nullity with no lawful purpose or effect. Now, she's saying that about a sworn affidavit that's going to be placed on the record as evidence. But she responded back in a letter, not rebutting the point stated therein. Just by her calling something incomprehensible or legal nullity does not solidify the fact that it's sworn to under penalty of perjury. And it's her now response to respond back with a complete rebuttal or a sworn statement, okay? Why? Because we know that an unrebutted affidavit does what, guys? Stand as truth. To further prove that, let's continue on. Okay, guys, so now as you all can see, we're coming again from the Court of Appeals coming out of California, and entitled the case was Cone versus Union Oil Company, right? Let's pick this up at the very top, as you all can see, very top, number 4, where it states, since plaintiff failed to file an affidavit in opposition of the affidavit filed on behalf of the defendant, the court, here we go, guys, the court was entitled to accept as true the facts therein stated. So, when you file your affidavits, right, and they're not coming back and they're not rebutting your affidavits, then the facts stated in your affidavit stands as truth, guys. And then you enter those facts in on the record as evidence. It's that simple. There's no need to argue the facts. But let's continue. It states, which were within the personal knowledge of the affiant and to which the affiant could competently testify. Okay? So in your sworn affidavits, the truth you guys can testify to. Okay? Why? Because it's your sworn statement. It's the truth. And they cannot rebut the truth. Thus, the lady wrote a letter and not a sworn affidavit. Because how can she be a court counsel respond to a sworn affidavit by use of a sworn affidavit if she don't have first-hand testimony or nothing she speak. It's just that simple, guys. But to further prove that, let's go to another state. Let's get more information. Let's go to a totally separate state, guys, and let's see if it's true in any other state. Okay, so now, let's go there. As you all can see, this time we're coming from where, guys? Michigan Court of Appeals. A totally different state, a totally different appeals court, right? And we're coming from Winsett versus Donaldson. But let's go all the way down to the bottom, guys. Let's go all the way down to the bottom, right? Let's pick this up where it states A. Let me see if I can highlight it. Right there, A, right? Then it states what? A review of the pleadings and affidavits discloses no dispute regarding whether the mother was married during the conception and birth of the child. Statement of facts contained in affidavits which are not rebutted by the opposing party's affidavits or pleading may be accepted as true by the trial court. Okay, guys? So again, once you file your affidavits, right? Even if you file your affidavits in response of a pleading or complaint, if those affidavits go unrebutted, then those affidavits stand as truth. Okay? It's just that simple, guys. That's it. That's all. All right? And again, case law to support that. But that's what I'm going to do for today. If you all need my help, hit me up in my email at yahuah@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. Shout out to all those that's been, rocking with me for a long time, and all my new subscribers, man. I appreciate it all, guys, and I appreciate those that just send me gifts and donations just to be sending them. I appreciate that too. I appreciate everything, man. I appreciate all the love. I appreciate the views. I appreciate everything, and I can't thank you guys enough, and that's from me to you guys. So again, continue to apply that pressure, guys. Let's keep this fight going. I know I've been making videos in a while. It's been like almost a month. But I've been extremely busy, guys. Just bear with me. I ain't forget about you all. I'm going to continue to drop these videos. I'm going to continue to apply pressure. And I'm going to continue to give you all remedy. You just have to put it together, okay? So again, that's all I'm going to do for today. With that being said, like, share, subscribe. Cop that merch, guys. And I say shalom.